Hey guys, I'm attorney Roger P. Foley, and today as I'm driving home in bumper-to-bumper traffic, so I'm not really driving, I'm going to talk to you about a recent case that was really, it was just a great case for me. It was a DUI. As you know, I do a lot of cases in DUI, and I had a particular argument that I was making. I filed a motion in state court and local jurisdiction here at home, and the state put together a 24-page rebuttal, and their argument was that I was asking for an expert to talk about the exercises, the standard field sobriety exercises at a DUI. Well, yes, I was calling an expert, and just so you know what what Daubert stands for in the state of Florida, and a few years ago, Daubert became the standard. And what Daubert says in DUIs is that you don't need an expert witness to tell the jury that someone smelled like alcohol, or they couldn't touch their nose, or that they were falling off the line, or that they stumbled, because it's common sense. Right? So common sense, a jury doesn't need an expert. The reason you have an expert is to make something complicated, make it easier for the jury to understand. Well, the state had argued motions like this previously and had been denied. The state had argued and they were successful. The defense had been denied the motions and been prohibited from bringing an expert. Well, I hired a really great guy that I met at Harvard University, who's out of Atlanta, Georgia. His name is Tony Palacios. And if you're a DUI attorney and you're watching this, I can tell you hands down, in my humble opinion, Tony is the best of the best. I have tried to stump him on things. I've taken his NHTSA course, the same one that he's trained thousands of police officers. I've taken his A-Ride course, and I became an instructor under Tony. So every time I had a question or tried to stump him, or thought that I had an angle in all of the classes, which were, 3 days on one, 2.5 days on another 2-3 days on another, Tony, just miraculous. And once I realized that I had a true expert, right? Everybody's an expert these days. Tony Palacios is a true expert. And I hired Tony, and I said, hey, take a look at this, right? And give me an evaluation, and look at the video, and look at what was done. Look at my depo that the officer had already given in his deposition. And this officer had made so many mistakes. Now, I knew this, right? I obviously have training in DUI, but I needed an expert, because I can't tell the judge, well, you did this wrong and you did this wrong, because, well, at least in Broward County, you can't use the handbook to cross-examine the police officer. Some stupid rule about it, some case on it, which seems ridiculous. So going back to Daubert says you can't bring an expert to explain basic things. So I changed my argument. I said, no, I'm not bringing the expert in to tell a jury or to tell a judge that my client didn't fall off a line, or they didn't see him stumble or fall or throw up, or, act sluggish, or hand an ID, a banking card instead of a driver's license. No, that's not why I was calling him. I was calling him because I had a horrible police officer. Now, not a horrible person. I believe a very nice person, a very nice man, but a police officer who, although he had been trained in the academy, had taken an NHTSA class, had taken a refresher course, had taken the A-Ride course, basically the DUI courses that officers take to arrest you, right, to establish probable cause, where he's trained how to do the field sobriety exercises, for him to know the ins and outs of what you're supposed to do, what to look for in personal contact, all of these things that this super big book, right? See that thick old book? Well, I got 3 of these big books. Well, this guy, look how many pages this is. I don't know, hundreds of pages, right? So this officer had taken this course and the advanced course, the A-Ride course. Well, he didn't know how to do HGN. Well, why is that important? Well, he's establishing his probable cause to arrest my client because he says that he didn't do HGN correctly, meaning my client's eyes wobbled. The problem is that the officer administered the test, the one thing you can call a test, the HGN, the horizontal gaze and nystagmus. He didn't administer it right. He didn't know what to look for. Like, he checked all the things. Oh, the client did this wrong, the client did this wrong, the client did this. But under cross-examination, under deposition, I realized this guy didn't know what the hell he was doing. He only picked one eye. He didn't know anything. Well, then he did the walk and turn, and he made mistakes there, and he didn't know the proper clues, and he didn't demonstrate the exercise properly. He didn't instruct properly. He didn't ask the client whether they understood. What he did was he simply said, like, when my client goes, hey, is this how you, like, is this what you, like, I just want to confirm, is this what you're saying? Can you repeat that? The officer gets mad and ultimately arrests my client, but says that, you know, my client's falling out of the stance and that he checks off things that he basically didn't pass the test. Well, I could see that this officer, so I went through the exercises with this officer during deposition. So I decided to create a motion to attack the arrest, the probable cause for the arrest. Well, I actually attacked the stop because I didn't think the stop was good. And then I attacked the reasonable suspicion to begin the DUI investigation because I was starting to think that the officer was kind of making stuff up, maybe not so honest, but maybe just not trained well. I don't know. Maybe you can pass the test, but you forget, 30 days after you took the class, what the class was about. I don't know. So I filed the motion. It was a lengthy motion. It was probably 12 pages or so. And the state objected. And they said, no, before we have a motion to suppress on Mr. Foley's motion, we want to file a Daubert motion, and we don't think that the officer should be, that the expert that Mr. Foley hired, Mr. Palacios, should be allowed to testify. A couple supervisors get involved. They say, no, we're not breaking it down. I go, this is a case that should be broken down, right? Now, the problem in this case for the defense, for me, right, was that my client had a high breath, right? It was almost double the limit, right? However, in the video, he looks good. He's polite. He's cooperative. He's not disheveled. I looked for an issue with the machine, but I couldn't find one. So I looked at, the day before, the day after, the week after, the month after, the day before, the week before, the month before. Couldn't find any problem with the machine. All that stuff is online, and you can pull it from FDLE. So couldn't attack that. So I have a bad breath, right? So that's a little scary to go to a jury trial, because if I lose, with a high breath, my client may go to jail, right? He risks up to 6 months in jail. I don't want my clients to go to jail. I don't want to lose. So I filed this motion. They counter. Okay, I say, well, how about a breakdown? Let's waste the time. Let's not waste time. Nope, we're not gonna give you a breakdown. He's gonna have to plead to the DUI. No, I'm not. My client goes, I'm not doing it. And I go, okay. So I tell the state, well, listen, if you get this expert kicked off, I'm gonna hire another expert, and I'm gonna have that expert come in and say, when you look at the video from a physician's perspective, and that my client, let's say, he blew a 1.5, he would have certain characteristics that you'd be able to see, like his eyes and his flushed face and things that you can actually see on camera, right? He wouldn't be able to stand straight for 10 minutes during instructions, or he wouldn't be able to answer, in an appropriate manner. He wouldn't have been able to pull over his vehicle immediately if he had that level of alcohol. So we were ready to go the whole distance. So ultimately, right before the motion, like literally 2 days before the motion is to be heard, the state calls and says, we're going to reduce the charge to reckless driving. Well, that's great, but they want to adjudicate my client guilty. No, I'm not doing that. My client's not going to do that, because if you get adjudicated, what have I told you in other videos? That means you can't seal it. You can't expunge it. It's there forever. Everyone will always know the guy had a DUI. No, we're not doing that. So haggle with them. They take off the adjudication. They give them a withhold. They wanted license suspension. I go, why? right? So we got some of these things erased. And ultimately my client said, look, if I can get the probation, 6 months probation, I'm good. It's a reckless, it's a withhold. However, the story doesn't stop there. I did a lot of work on this case, spent a year on this case, right? So I had to ask the judge, you read the motion. I have to ask you, the state has been successful in other cases, but I framed my motion in a different way. I attacked probable cause. I attacked the credibility of the officer. I attacked his training. Would you have allowed my expert to testify in the motion to suppress? No hesitation. Yes, Mr. Foley. It's on record. I'm going to get a recording of it because so many other cases have been lost in Florida, not allowing an expert to come in, but it's a different way of attacking the argument by attacking the way that they actually administer the exercises. Because in my opinion, if the judge was going to deny my motion and not let the expert testify, my argument was going to ultimately be, well, Judge, why is there the National Highway Traffic and Safety, a federal organization that teaches DUIs to police officers, if it doesn't mean anything and it's just layman's terms and anyone could see if someone was drunk? Of course not. The government is involved. They have these big ass books, right? They spend, I don't know, thousands, millions. I mean, every police officer is trained on these things. They're in the academy. There's follow-up classes. There's A-Rod, right? There's instructor courses. There's DRE. What would be the purpose? And sorry, I can't look at the camera because I got to drive. What would be the purpose of having all this training and all these expenses and this government program and all the testing that they've done over the years if it didn't mean anything? The judge agreed with me, said, yes, Mr. Foley, I would have let it in. She put the caveat though and said, and this is where, not so good, I don't know if I would have let the jury see it if I didn't grant your motion. However, I was denying the state's argument that your expert couldn't come in under the Daubert standard. I got to tell you, folks, first of all, great judge. I don't want to say names, everything. Yeah, I don't want to put anyone's names out there, but this is just a great judge, a judge that takes the time to listen to both sides, is an academic, someone who knows their stuff. I mean, this judge is just a staple. You don't get judges like that. Sometimes you get judges that they've only been prosecutors or have only had limited experience and maybe they can't hack it in the private world. And no disrespect to judges, but there are a lot of judges out there that, get that government check. This is a very smart judge, a judge that takes their time, that listens to both sides of the argument. And that's why I thought I had a shot, because I knew I had probably the smartest judge in the courthouse. And I thought that the argument was worth making, and my client wanted me to make the argument. And I just debated back and forth. Once they filed their rebuttal to my motion and basically wanted a Daubert hearing to decide whether or not Mr. Palacio came on, would be able to testify. Mr. Palacio and I, hours of conversation and debating, and he's like, man, I think there's an argument there. I think you got something. I'm curious to see if she'll let me testify. And, so it was really good that this judge ultimately said on the record, granted it's not case law, because if it was case law, I think it would have put a sliver. It would have given the defense more options for other cases. But again, when I'm representing a client, it's that client's best interest. For this particular client, I gave him the options, and he ultimately said, I'd rather take the plea. I know you put a lot of work. Actually, he said, whatever you want to do. And I said, I'm sorry, but I can't make that decision because I don't want to make a selfish decision. It's got to be your decision, and it's got to be, what you decide, knowing all the information that's available. And the client was great. He goes, look, I'm gonna take it. And I said, hey, I'm just gonna ask the judge, what they would have done. And the judge was very forthcoming and said, no, I was letting your expert in for your motion to suppress, definitely. I don't know. I'm unsure if I would have let your expert testify in the trial if I didn't grant your motion. But the reality is, if Mr. Palacios would have testified, I truly believe the credibility and the training would have come under immense pressure, and I think that the judge would have granted the motion. That's my thought. But, you know, hey, maybe I would have got that big fish. You know, I don't want to make a story any grander than it is. But for me, it was definitely something that I appreciated, that I went through all the work, even though it was anticlimactic and we didn't actually argue the motion. The fact that the judge took the time and said, yeah, I was granting your motion. And I was denying the state's motion and I was allowing you to bring your expert in. Then it's just me putting, you know, all the elements together of what I needed to do and make sure the judge understood it. But I think I'm pretty good at that, but who knows? But anyway, that's DUI, that's Daubert, that's expert witnesses. Fight. I just want to let you know, I called 2 or 3 high-end DUI guys to ask their opinion. They all said, no shot. I don't think it's going to be granted. One attorney said, maybe you go to trial. And I go, yeah, I don't want to risk my client going to jail. Everyone basically said I had no shot at the motion. The judge said, yeah, the motion was getting granted. So, woo-woo. Yeah, I'm happy, guys. I'm sharing a story. Hope you enjoyed it. But always make the effort. If you're an attorney watching this, if you're a young attorney watching this, make the effort. If your client is willing to allow you to make arguments, right? Because it's the client's choice of how he wants to handle his case. Maybe they just want to take a plea. Maybe they want you to file motions to suppress. Maybe they want a trial. It's their option. Inform them about all the possibilities. Tell them what's good and bad for them in each, and let them make the choice. But when a client gives you the go-ahead and goes, file away, right? Do what you do. Oh man, it makes you feel good. Because this client over the year called me and just said, man, and this client's actually going to do a video for me, and he's going to do his own video rather than doing a short little 15-second like, thanks, Mr. Foley, and hey, blah, blah, blah. He's actually going to take the time to do a video in his own words and take the time to explain his version of how it all went down. So I'm really appreciative. I hope you enjoyed this story. I'm attorney Roger P. Foley. DUI, criminal cases, personal injury. I'm here. See y'all.